How are you all? Welcome to class on Friday. I'm not taking attendance as I promised, but it looks like you all sat in exactly the same seats as you normally sit in, so I'll try to make use of the chart as best I can. And we are talking about the material on the validity of the forms, and we got through, we started the problems, right? So we talked about problem 24 and 25. Does that sound right?
I think.
So we're moving on to 26. All right, well, let's just take a second and talk again about, we're talking about the validity of the forms here. We have two documents that we're worried about. We're worried about the security agreement, and we're worried about the financing statement. They serve two different purposes. The security agreement is the contract that creates the security interest. The financing statement is the document that perfects, i.e. puts on notice the rest of the world of the existence of the security interest. So they serve two different purposes. We looked at, talked a little bit about the purpose of the financing statement being a notice filing, meaning that you have to understand how the system works in terms of how people use it in order to understand what they're going to do with it, what we need to do with the document, and what the document needs to say. We focused on the fact that the filing is indexed by last name of the debtor. So last name and then first name. Actually, it's not last name anymore. It's now surname. So surname and first personal name, or organization name if there's an organization. And that's both how it is filed and indexed and searched in the system. So getting that information, critically important. So a lot of the reading that we did for today focused on how do we figure out what people's names are. And we started talking about individuals. Not as easy as we thought, but we've making a choice in this class that we're going to go, for our purposes in class, alternative A, where there's basically two answers, right? There's the driver's license, or if they don't have a driver's license, then there's part B to that answer, which is their name. But if you put in the surname and the first personal name, Dimitri, I think you answered that question, right? It was, you don't remember, but I think you did. The point was that that at least is sufficient if you've got that. All the other information that you might have is great, doesn't matter. Surname and first personal name gets you to a proper filing under the second alternative if the person doesn't have a license, a driver's license. Okay, questions about what we did so far. I want to make sure that what I just discussed makes sense to everybody. That seems, we're on the same page with that? Okay. When we're talking about registered organizations, we see that there is an alternative, which is you go to the governmental agency that formed the registered organization, and it's whatever name they have. But then we looked at the search logic, which was contained in that first case we read. And let me make sure I'm on the right page here. Was it 79? 79, Ohio Administrative Code, Section 111-11-62, search methodologies. What you need to enter for the name of a registered organization is dictated by this search logic, because if the name is misleading, and then actually the standard is seriously misleading, then the filing is inadequate. So seriously misleading is the standard. If you can't find the person, the individual or the organization, by the way you've put the information in, the document is seriously misleading and it is not properly filed, it's a nullity. It's like it didn't happen. Okay? So knowing that, and because it's all software based, there has to be a logic, an algorithm that the software uses to find things. And so we saw in there, in that list, that, for example, I made fun of Ohio State University, right? They want to be the Ohio State University. The actually would be dropped by that search logic. It would just start with Ohio, all right? If there's what they call noise words at the end of a name, because they're a corporation like Inc. or LLC or LLLP or whatever, that's also dropped. They get rid of spaces, they get rid of punctuation, and they basically compress the word, and it's just literally letters in order that they're entered into the system, and that's the search log. Spaces are deleted too.
I just want to talk about the facts of this case a little bit.
Yes, let's do that.
Because they left the H out of technology,
Yes.
they got out of this loan. They don't have to pay back the $3 million or however much.
Okay, so let's understand. What is the circumstance of the case? So now we're looking at, this is the Beans Farm of Homestead, right? No, it's the next case, right?
Yeah, the technology company.
Yeah, the technology company case, that is the...
On 80?
Yeah, on 80. So it just follows this case, that's right. So what's the mistake? They drop H from the word technology, okay? If a word is misspelled, is it likely to show up in the search logic? No. Correct spelling is expected. Okay. The first thing I would suggest is suggest the use of cut and paste as much as possible, right? Go to the Secretary of State's office, see what the official documents are, cut and paste and put it in. You can never make a mistake that way. At least minimizes it. But second, what's the circumstances of the case? Why are we litigating this? What court are we in?
Bankruptcy court.
Okay, this is really important. We haven't studied priority battles yet. The reason this is in bankruptcy is the debtor filed bankruptcy. So there's another person out there that's going after the assets, and that's the trustee in bankruptcy. And I think I lectured early on, who does the trustee in bankruptcy work for? The unsecured creditors. The bankruptcy trustee is trying to pull together as many assets to sell off and pay off the unsecured creditors. The trustee in bankruptcy does not work for the secured creditors. They work for themselves. They're perfected, they have priority, they don't need the help of the trustee in bankruptcy. So you're the trustee in bankruptcy, you want to beat the secured creditors because they claim assets that you want to sell. So what's a great way to go after them? To say their filing was inadequate. If they're not perfected, they lose to a lien creditor, i.e. the bankruptcy trustee. Now, there's two parts to these documents. There's the security agreement and the financing statement. This case is about the financing statement. Is it about the security agreement? As between the creditor, the original secured party, and the original debtor, yeah, he owes the money to that person. That debt doesn't go away. It might get discharged in bankruptcy, but it doesn't go away.
Oh, okay.
Right? So that debt still exists because of even after this case. What goes away is the ability of that creditor, that secured party, to take the assets, sell them, and get paid off. So it's not like they lost their loan, it's just that their interest in the assets now is mixed with everybody else's, and they only get a fraction of what they were going to get. Yeah. So it's a great question, and we will study this more in greater detail, but it's why this filing system is so important. The trustee in bankruptcy is going to try and kill the secured party's security interest, and the best way to do that is to say, or the first way to do it is to say, you didn't properly perfect. You didn't make a filing that was adequate. Does that help?
Yes.
Yeah, okay, great. Great question. One way to tell what we're talking about, whether it's a financing statement or the security agreement, is who's litigating. If it's the original secured party, who is the plaintiff, and the debtor, who is the defendant, their case is about the contract. They have a contract, and that security agreement governs that relationship. If it's the bankruptcy trustee or another creditor, that's the plaintiff against the debtor, then the question is priority, and are they perfected? So if they lose their priority, they lose their claim to the assets. So contract does not go away, still enforceable. It's why we don't care about the name. You don't have to write the name on the contract the right way for the contract to be enforceable. It doesn't matter. The secured party is talking to the debtor. They know each other. It's only the financing statement where the name is so critical. Okay? Now we're going to talk about, next week, we're going to talk about description of collateral again relative to the security agreement. It will come back, right? What collateral is covered is important in the security agreement. who the debtor is, they know the debtor. They lent them money. Okay? Does that help? It's a great. So the first case, the farm equipment case, what's the mistake? They left off part of the name, right? Right. This is the John Bean's Farm of Homestead Inc., right? Yeah. What did they file under? John Bean Farms. But that's not the name of the debtor. The debtor is a corporation. Its name is John Bean's Farm of Homestead Inc. How many pages did the bankruptcy court say that the person would have to click through to get to the actual filing? 60 pages. So the argument was the standard search logic included hitting the back button. How many times did they have to hit the back button? 60 times. No, that's not what the system is designed to do. It's a notice filing system. You search using the standard logic. The logic is what's set out in the case. It didn't come up under that logic. Done. This court, the court hearing the appeal got it absolutely right.
So I think they ended up saying that you were allowed to say 1 page back or 1 page forward. Is that like?
I would disagree with that. I think what they said is maybe we might entertain such an argument,
okay.
But this is not that case.
Way out. Okay.
This is 60.
Okay.
And I think a better argument is you don't have to hit the back button once because the statute says and the regulations of the filing office said there's only one way to do a standard search. Fill in the name as it appears in the records and hit return.
Okay.
That's it. That's all you have to do. Anything else is more than the standard search logic.
Okay.
So I think the court was just being like, well, maybe we might agree to a 1 page,
Right.
but that's not this case.
Okay.
Yeah. And for our purposes, no, you don't have to hit the back button. But I can't tell you can't find a court that says, well, one click.
Right.
I disagree with that, but I can't tell you that you won't find a
Okay.
court. Yeah. Good. So good discussion about those cases. So let's look at problem 26, right? Isn't it the next one we're doing? Or did we do 26?
We did 26.
Yeah, 27. Sorry, thank you. So the first problem after the first case. So EDM Corporation routinely did business as EDM Equipment and was commonly known by that name. So when the lender filed its financing statement, it listed the debtor as EDM Corporation, DBA EDM Equipment. Is that the correct name? Why not? There was a nod for our folks playing at home. Somebody nodded. No, it's wrong. That's not the correct name. Why?
Well, I can't read my handwriting.
Can't use a DBA.
Right. The statute says that. It's not correct to use a DBA. You should not use a DBA. And worse, what happens when you add the DBA into the filing?
Becomes misleading.
The software, the search logic gets screwed up. And you don't get the name coming back. So the right answer is, and I think the answer in the case was, the DBA messed up the filing. Right? In resolving this problem, it may be useful for you to see a common administrative rule by most states. Here's the one, right? Read the logic. And it tells you what you're supposed to put in the name, okay? Yeah?
Is a DBA the same thing as a trade name?
It is. Some jurisdictions have, just as a point of reference, nothing to do with Article 9. Some jurisdictions have DBA statutes, which is if you operate your business under a trade name, that's not the name of the business. So it's more common for sole proprietorships. You have to register your DBA. I did work in Boston. Every company we worked for filed a DBA if they had a trade name that was different than their corporate name.
Oh, okay.
Yeah. Most companies don't. They operate under their official corporate name. But like Procter & Gamble would be P&G.
Mm-hmm.
They might register, that might be their trade name. They're doing business as P&G.
Mm-hmm.
Yeah. All right. Problem 28, worldwide widgets. What's the problem here? Where's the mistake?
It's misspelled.
By who? When is it misspelled?
Whenever they're putting it into the system.
The document filed to create the corporation misspells the name. What's the name of the corporation? With the D or without the D?
It depends on what's on the organic.
All right, well, but we're talking about the organic record, right? What does the organic record say? With a D for widget or without a D for widget?
What would,
Well, what does the problem say?
see, that the document identified the company as World Widgets, which is without the D, but the state's database correctly listed the company as Worldwide Widgets with the D.
Okay, the database did, but what does the filing say?
The misspelling.
The misspelling. What were the documents that were sent to the Secretary of State's office? What did they say? No D, right? I don't care what they said in their database. Their database is wrong. It's what the documents that are officially recognized by the state as the incorporation documents, or LLC documents, I think in this case, right? That's the name of the company, not the database. The database, somebody typed that in, right? They said, oh, it's widget, W-I-D-G-E-T, right? That's how it's spelled. But that's not what the paperwork said. It said W-I-G-E-T. So what's the name of the company? Yeah, Worldwide Widgets without a D. Yeah, Wiggins, right. Okay.
So then when you go to file, in like like a financing statement in the state's index, would you have to you would leave out the D and then also the incorporate? Is that right? Because
Well, the ink is a noise word, so it doesn't actually, according to the search logic, it gets dropped anyway.
Oh, okay.
But so it's okay to include it because it gets dropped.
Oh, okay.
Yeah, if the ink is, if you get the ink wrong because it should have been corp, it's still a noise word, so they don't search under it, right? But that's dumb. You shouldn't do that because, okay, maybe you're in a state that includes the noise words as part of the search. Ohio doesn't. Ohio drops the noise words, the statements about corporate status. You have a question?
Well, yeah, for Article 9 filing purposes.
Yes.
They have to file stuff spelled incorrectly.
Yeah, sounds dumb, doesn't it?
Okay,
But who made the mistake?
the company,
Yes.
yeah, they did.
And so the bank should just not, right? So how do you verify what the official name is of a corporation? Yeah, but how do you verify it? How do you actually verify what the name is so that you have a document that tells you officially what the name of the
You
document
have to find the original paper.
is? Yeah.
The organic.
You would just have to find out like whatever state they're incorporated in, and then I guess search it backward.
All right, now, you're the associate at the firm filing the, you've been tasked with typing in the financing statement, which you wouldn't be because it's the bank, but let's say it's you. You're filling in the financing statement. Are you nervous about getting this right? Yeah, because what happens when you're wrong? The company loses its perfection. Big deal, particularly if it's millions of dollars. It's called malpractice. How do you avoid malpractice? Yeah, well, that too. But that doesn't avoid the that pays for it. Yeah. How do you avoid it?
Can you do it under both?
What?
Could you file under both?
You can absolutely file under both. So that's one way to do it, just to be sure, right? You file under both and then you're fine. But officially, how do you know what the name of the corporation is? You get certified copies of the certificate of incorporation, or if it's a LLC, articles of organization, whatever they call it in the state. The Secretary of State's office will issue certified copies that certify the name. So if you ever have a problem, you can pull out that piece of paperwork that will have a stamp on it from the Secretary of State's office. And I will tell you that this is one thing that slows things down, because you should order them early, but they need to be effective, hopefully, as close to the closing date as possible. So you want to order them late, but not too late. Now, I will tell you, loans have been closed throughout the last 50 years with documents that were received after the closing. That's life. But ideally, you get a piece of paper from the Secretary of State's office the day before the closing that has an official stamp that says this is the name of the corporation. And usually what it is it's a photocopy of the paperwork that they sent in. And if they had gotten that, would it have said W-I-G-E-T? Okay? That's how you verify it. Practical tip. certified copies of the articles of the organic record. Okay? All right, and then PTM, millions of dollars, right? Secure transactions, not very interesting, but important to know the details, right? Read the statute closely. Okay, so we talked about the cases. 29. Barbara Song borrowed $50,000 from Octopus National Bank in order to start a business called Barb's Interiors. Interior design being her specialty. O&B and Ms. Song signed a security agreement showing her as the debtor and giving O&B an interest in inventory and equipment. O&B duly filed a financing statement. Subsequently, she married Fred Dancer, and she changed her name to Barbara Dancer. She borrowed another $50,000 from the Night Flyer Finance Company, which loaned her the money after searching records under Dancer and finding no prior encumbrances on the business's inventory and equipment. Did O&B lose its security interest because it failed to refile with her name change? All right, who actually took the time to read through the statute to figure out? All right, let's work through it.
I don't know if I'm right or not.
No, that's fine. That's what we're doing. Sam, is that right?
Natalie.
Natalie, sorry, you're sitting in. Yeah.
I guess I'm in Sam's spot.
Yeah.
But
It doesn't matter. Natalie.
I'm Sam.
we'll say Malkin.
Oh,
Yeah.
okay.
Anyway, I put that they had 4 months before they actually risked losing their security interest.
Okay, let's take a look at the statute. What section are we looking at?
507C.
Yeah.
7C.
All right. So, what does 507C2 tell us? Does a name change affect a security interest?
If it's more than 4 months after the file's financing statement, then it becomes seriously misleading unless there's an amendment to the financing statement.
Okay, so, but is that to all collateral? So first of all, great, you found the right section of the statute. Great, you've identified the 4-month window of opportunity here. Great. What collateral is subject to losing the perfected security interest?
It just says collateral, it doesn't really specify.
Well, look at C2.
Oh, collateral acquired by the debtor?
Yeah, when?
More than 4 months after the filed financing statement?
Okay, that's called after acquired collateral.
Okay.
So would they be unperfected with respect to the original collateral?
No.
No. So, let's stop.
Okay, thanks.
So the first thing to ask is, if someone changes their name, does that make an existing financing statement seriously misleading with respect to collateral that was covered when it was first filed? No. Does it make it seriously misleading with respect to collateral that was acquired by the debtor, assuming it's covered by the security agreement, 3 months after the name change?
No?
5 months?
Yes.
Okay. If you are a secured party, you have to track the name of your debtor over time because it can change. Corporations change their names all the time. You only really are worried about collateral that is acquired more than 4 months after the name change. So let's say, I'll give you an example where we just do not care. You buy a car. You buy the car under one name. The only collateral covered by that loan is that car. Your name changes. You go to court, you do whatever, you change your name. Is that financing statement ever going to be seriously misleading with respect to that car? Car's a bad example because there's a certificate of title, sorry. You bought a TV. You bought a TV and only the TV is listed as collateral. There's no other collateral. And there's no after acquired collateral. There's just the TV. Will that financing statement remain valid for the entire time that it exists? Yes. This rule protects financing statements that are filed under the debtor's name at the time of the creation of the security interest for all time, for all collateral that existed at the time of the filing. Does that make sense? Does that make sense?
So if it had been like an account where the collateral would change, that's when they would have to change it?
That's when we start getting worried, right? So you gotta have a monitoring system if you're a secured party, because what happens? After 4 months, the financing statement becomes seriously misleading with respect to after acquired collateral.
Why 4 months? I mean,
Because it's a balancing. They wanted to give banks, they wanted to put the banks on notice that they needed to check. But they said it's not really possible to check every day. So they said they give them you get a check from the debtor who's making a payment on the loan. All of a sudden you look, and instead of it saying, what was her name? Her name was,
Dancer
Barbara Song.
or song, yeah.
all of a sudden you get a check that says Barbara Dancer on it. Somebody at the bank should look at that check and go, wait, her name changed. Oops, we gotta do something, right? So they're putting a risk onto the secured party to pay attention to the debtor's name.
To the TV that night?
But since it's the TV, since there was only one piece of collateral in the hypo I gave, we don't care.
So will that forever be registered if under, so say that, I don't know, what was her name? Barbara Song?
Yeah, so that financing statement that says Barbara Song will remain valid forever for that collateral, for that
Somebody
television,
could search that.
because there's no new collateral being added.
So somebody could search Barbara Song and find that she has this TV forever, even after her name change?
Yeah,
Okay.
well, financing statements are only good for 5 years.
Oh, okay, for 5 years.
They have to
And then-
refile after that.
Okay, and then if she bought the TV as Barbara Dancer,
Yes.
I get 4 months after that, it would go filed as Barbara Dancer, and somebody would have to look for it that way, but I guess I'm just confused, if somebody, so say she bought the TV within 2 months and files it as Barbara Dancer, like how would they, it's the time in between that I'm confused about. I don't know if that makes any sense, I'm thinking out loud. It's the time before the 4 months, it would get filed under the new name, right?
So the existing security agreement
Yeah.
allows for the debtor to have, or says that the debtor is granted a security interest in collateral that is acquired afterwards. Right? That's the circumstance that has to apply.
Mm-hmm.
Now let's take a look at the comments, right? Comment, I believe it's 4, talks about changes, right, that have, post-filing changes that render a financing statement seriously misleading have no effect on a financing statement, so it remains effective, okay? Let's see. So example 2. Debtor's driver's license expires 1 year after the entry of the debtor does not renew. Okay. If you read through the comment, you'll see that there are multiple kinds of changes that can occur. The name change one does not make the previously filed financing statement seriously misleading. It's still valid, except as to collateral acquired 4 months after the name change. Yes?
So what if Barbara is awful and she has this TV as collateral
Yeah.
and she changes her name and she wants to get another one and she's like, well, they're not gonna find Dancer, so she uses the TV as collateral again.
That's what I keep thinking, like somebody could go do something in those 4 months, I don't know, I have to
So,
think about it.
great question.
Yeah.
So if the financing statement is still good, we're going to see later in the priority battles, it's still good, right? They're still perfected. So she goes under the new name and uses this TV as collateral again.
Mm-hmm.
What is the burden on that second secured party to do? What do they have to ask her?
Does she change her name?
Yes.
Okay.
Have you ever filled out a form that asks, is this the same name you've always had?
Right, okay.
The burden is on the later creditor to ask the question, has your name ever changed?
That's what
And that is a
that's what I was
reasonable
trying to-
burden, right? When you're talking to the debtor, to the potential customer, and you're asking them to fill out paperwork, ask them, has your name ever changed?
That makes
That's an easy question to ask. That's a proper burden. It doesn't, it seems like a very low-level burden, as opposed to making the existing creditor always immediately change the document. Okay. Some debtors are bad people, and they do exactly this. They cheat, lie, and steal. We put the burden on the new creditor to ask about name changes, and we put the burden on the existing creditor to ask about name changes that affect collateral acquired more than 4 months later. So there's this shifting burden. Does that help? Does that make sense? And you're going to forget this the minute you walk out of here, right? But there's an answer. It's called 507C. You don't have to memorize this. It's in the book. Trust the book. Trust it. Yes?
So like, I think like the prior financing statement is fine, but let's say, she comes back to she gets remarried and changes her name, and then comes back to the bank, and we take, I'm assuming I'm the bank, and
Yeah.
I take an interest.
So they make a new loan.
Exactly.
Yeah.
But let's say it's within 4 months of changing her name, can they still just use the old name? Is that they're safe to still use her old name?
Well, you tell me. What does the statute say?
I think they're fine, yeah,
And why do you say that?
because it's within that 4-month window.
So do you feel good about that answer? Do you have statutory authority for what you just said?
I think so, yeah.
No.
No?
Read the words.
Oh, no.
You tell me whether you think you have statutory authority for that statement. They lend her more money
Right.
under the existing financing statement.
Oh, under D. Okay, it wouldn't just be I was assuming it's a completely new.
Yeah, let's say it's a new one too. Yeah. Okay, so it's a new loan.
Right.
So describe me the loan. What transaction is happening? She comes to them and she wants to buy.
Like a tool or something.
Okay, what's her name when she makes that loan?
I guess so they need to go with the new one.
Well, it depends on the description of collateral in the financing statement.
Okay.
If it says equipment and she's using the TV in her business, does equipment, let's say it says, the financing statement says equipment, and she buys a desk instead of a TV within the 4 months after. Is the financing statement still effective?
I would say no.
Well, what does the statute say? What's the statute say? Tell me how the 4 months works. Is the financing statement effective after her name change? For how long?
Oh, wait, for the original piece of collateral is good.
Well, now we're just talking about the financing statement. I was giving you an easy example. So he's up the ante. He's made it a little bit more complicated. The financing statement says equipment. She gets a new loan, but there's an existing financing statement on file that says equipment. Would that financing statement cover security interest in this newly acquired equipment with this new loan? Well, let's see. Put aside the name change. Does the existing financing statement cover the new loan if it says equipment?
Is it the same lender?
Yeah, same
okay.
lender, or it could be different. But no, it has to be the same lender because it's the same financing statement. Same debtor, same lender. She gets a new loan. She buys a new piece of equipment. The financing statement says equipment. Does equipment cover equipment?
Yeah.
Yeah.
Okay. Yes. So no name change. Let's forget about that. Financing statement says equipment. The bank says, hey, we like you so much, we're going to finance that desk you're going to buy, right? It's equipment in her business. Just accept that. Is it covered by the financing statement? Yes, absolutely. Equipment is equipment. Now, let's do the name change. She changes her name, goes in 2 months later, says, I want to buy a desk, signs all the paperwork. They don't refile. They don't change it, they don't amend it, they just say, cool, security interest in the desk. Is it covered?
Yes.
Why?
Because it's within the 4 months.
The financing statement is still effective to cover collateral acquired before the date of the name change and up to 4 months after the name change.
Okay.
Does that make you feel good? No. I see distress in some faces here.
So why wouldn't they have to file the new
Yeah,
agreement with her?
Okay,
name on
do
her
they need a new
driver's
security
license?
agreement? Yes, if the original security agreement only said TV, does TV cover the desk?
No.
No. And we have not studied the description of collateral in the security agreement. That's
Okay.
next week.
Okay,
But TV is not a desk, is it? Can we agree on that?
right.
Okay, So they need a new security agreement that says desk. Do they need a new financing statement if the financing statement says equipment? Because equipment is equipment, right? The desk, the TV, they're used in her business, still equipment, okay?
Okay,
So the financing statement, you don't need one.
so she's just adding collateral.
Yes, and that's,
Is that really a new loan though? Is that a?
well, they could be. I mean, sometimes it depends on how they've written their documents. Some companies enter into what's called a floating lien agreement. It
Yeah.
covers all collateral whenever required, now or later. And they get a loan and it's a line of credit. And they say, every time I buy something, lend me the money so I can do it. And the company says, great. The bank says, great. They buy a TV, they give them a check to buy the TV. They buy a desk, they give them a check to buy the desk. That's one type of arrangement. The one we described was a very specific loan for one piece of collateral.
Mm,
Okay?
okay.
That does not cover new collateral. If it says TV, a TV is not a desk. Not covered.
Okay.
But the financing statement says equipment.
Oh.
The
oh.
desk and the TV are both equipment.
So you can just use the same financing? for
Absolutely.
New loans?
Yeah, you don't have to refile every time you
Okay,
got a new
that's why I
loan.
was-
Yeah, no, it's a great question. You do not have to file a new financing statement just because there's a new loan.
Okay.
Yes, no.
So the TV that she got.
That's why we're here.
Under her name.
Yes.
They filed the original financing statement.
Yes.
That is good no matter what, even if her name changes, they don't correct it.
Because there's no new collateral.
But all the stuff that's new collateral after that date, they would have to file it to get that new.
They'd have to amend the original one
Okay, yeah.
or file a new one for the new stuff.
Okay,
Either one would work.
all right. I think
But, I mean, the amendment would work. They just have to amend to change her name.
Okay. I think I
Yeah.
got it.
Okay. We will look at this again and again because it's all about priority battles. So this comes back. This is not the only time you're going to hear this. I promise you. We will talk about priority. Now we're just talking about name changes. Okay. Natalie, you feel it?
Yeah, I think I'm okay for now.
As I said, particle physics.
Right.
All right. Problem 30. What's the issue here? We have a couple of companies, American Electronics Store, and the latter ran into financial difficulties. Its assets were sold to a new electronics concern, Voice of Japan, which moved into the same retail location. Must National refile to keep its security interests perfected in the accounts actually transferred by American Electronics to Voice of Japan? Why not?
It's
The other
somewhere
side.
in the statute,
Yeah, I think it's in 9310.
9507A.
Okay, 9507A. What's 310?
310 is for when the filing is required to perfect security interest.
Yep. When a filing required to perfect a security interest area, right? 310 is you're filing a financing statement. It just tells you how to perfect.
Okay.
All right. So 507 is, does the change in the relationship here between the debtor and the collateral affect the filing of the financing statement?
No, because a filed financing statement remains effective with respect to collateral that is sold, exchanged, leased, licensed, or otherwise disposed of.
You feel good about that answer?
Yes.
It's in the statute, right? You don't have to think, right? We can ask about the policy questions, but the answer is in black and white. It says you don't need to refile for the existing collateral that is disposed, right?
Okay.
Does that make sense? 507A? It's okay to be worried about this. Ask your question. What is it that's
No,
worrying?
I'm okay with this one.
Yeah, this one's easy, right? Because 507A, and think of it from a practical perspective. They don't have to keep tracking down what the debtor is doing with the collateral. If they're selling it off, they're giving it away to people, we're going to see later there are ways that the security interest goes away. But for our purposes today, the financing statement doesn't need to be refiled. Okay? We're not talking about what happens to the security interest. For right now, the question is, do they have to refile? And the answer is no. The original financing statement remains good. What's the problem? Is it seriously misleading? In the sense of practically.
Well, the company is a different name, so, yeah.
And the assets are owned by somebody else, right?
Yeah,
So what's the problem?
you couldn't find it in the.
Collateral can have secret security interests in them because they could be from somebody else who sold them to you. So, what question do you ask when somebody is applying for a loan about their name? Have you ever gone by a different name? What's the question that this question makes you want to ask?
Who owns the debt?
Where did you get your collateral? Because you can acquire collateral subject to a perfected security interest. And the new bank can all of a sudden lose priority because an existing financing statement with another company's name on it can cover this collateral. That's the consequence of 507A. Does that make sense? You don't have to refile just because the assets are sold. So that means the perfected security interest travels along with the collateral.
So the burden is on the lender to.
The second lender.
To check all possible prior owners to that.
They need to
loan?
know, what's the word, the provenance of the collateral.
Okay.
Now, I'm not telling you that they check. I'm telling you that the law protects the original creditor.
Right.
It's a risk assignment. It is not, nobody actually asked this question, Bert. It's not a common question. Did you acquire collateral subject to somebody else's security interest? That's kind of hard to sort of pin down. It's a risk allocation. They've essentially assigned the risk to the second lender. That some collateral that the debtor owns comes along with an existing security interest. Does that make sense? So 507A is really just a risk assessment, risk allocation provision. Because practically speaking, people don't typically ask that question. Unlike the name change. That one they do ask. This one they don't tend to ask. Okay. Accounts thereafter acquired. Different answer? What's the answer there? Accounts generated more than 4 months after the sale.
I have yes, but I don't.
You would have to change, they would have to reflect a new name. Yeah.
New name, right? Yeah.
Okay.
New debtor, new name, have to refile after 4 months. It's the new accounts, not the existing accounts. Not the sold accounts. Your answer is correct under 507A for the sold accounts. It's the new accounts, right? That make sense?
Yeah,
Yeah.
I wasn't sure if it was yes or no. I had yes, but I think.
And yes is correct. Yeah, they have to refile.
Would they amend or refile in that case?
Let's see. So it's a new debtor. So I think they'd have to have a filing in place that has that new debtor's name. Yeah. Let me think about that. An amendment, would it work? It's not a name change, it's a new debtor. Yeah. Now, the problem here is also, does the security interest continue in the new collateral? They sold, it's a new company entirely, right? How does the original security interest reach collateral owned by another company? It doesn't. I think they needed a whole new security group, actually. Okay. We good? Okay. Do we get the same result if American Electronics Store merges with Voice of Japan and the new entity is called Voice of Electronics, Inc.? How does merger work here? So by the way, I just want to say the first example in comment 3 is the example where the collateral is sold, okay? So if you look at the comments, it says, D Corp is an Illinois corporation. It creates a security interest in its equipment in favor of secured party. Secured party files a proper financing statement in Illinois. D Corp sells an item of equipment to B Corp, a Pennsylvania corporation subject to the security interest. The security interest continues and remains perfected, notwithstanding that the financing statement under D and not under B. Okay? Now, we haven't done choice of law yet, so the second part of that answer don't worry about, but, okay? So what's the answer to the second part of this? If the debtor merges,
I have a no according to 9203 E2. Another agreement is not necessary.
so, and so let's take a look at 9203 what?
E2,
Okay?
the book also references D.
A person becomes bound as a debtor by security agreement entered into by another person if by operation of law other than this article or by contract the security agreement becomes effective to create a security interest in the person's property or the person becomes generally obligated. So what's the law other than the law of Article 9? That's what the statute says, right? If by operation of law other than this article. What law are they referring to there?
Because there'll be contracts or
Anybody take BizOrg?
taking this word.
We're in it now.
What happens with a merger of a corporation?
We're not.
You're not there yet.
Well, I would think that if you merge with a corporation, you just assume their assets,
Yes.
liabilities.
The law of corporations says what happens to the assets of a merged corporation. In fact, the merged corporation gets title to all of the collective assets of the two corporations. So that's law outside of Article 9. So, is this a business orgs class?
No.
So, would I have to tell you what happens?
Yeah.
Yes! I would have to give you, if there's other law that applies, I would never write a problem that would assume you know that other law. So I would make a statement to the effect of, under the law, the LLC statute, the merger of two LLCs results in the new LLC obtaining full title to the assets. Okay? So I will give you that. I don't assume you bring in knowledge from another class into this class, so you won't be tricked. And hopefully when you see that I say law outside of Article 9, that should go ding, 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 ding. Oh, I think I've read that phrase before. 9203. And then that was D. And what is E? If a new debtor becomes bound as a debtor by agreement, the agreement satisfies B3 with respect to the existing or after acquired property of the new debtor to the extent that the property is described in the agreement, and another agreement is not necessary to make the security interest enforceable. Cool. Making sense?
Wait, so was E by agreement and D was by some other law?
Yeah.
Okay,
So,
same thing, so,
Yeah.
okay.
so they don't have to refile.
D and E protect both the original and after acquired collateral without having to change the records. Should you refile? Would you refile? Does it hurt to refile? Kelsey, would you refile?
Yeah.
Yes, because you're a cautious person who wants to make sure that everything is just A-okay. There's no harm in filing again. You doesn't do anything wrong. You can file when Barbara Dancer changes her name, you can file immediately. Do the amendment right away, right? Filing extra documents doesn't hurt you, okay? You have to file the correct documents under the correct information, but being cautious doesn't destroy the previous filings. So they're still good, and the new filings might be good as well. They may not be necessary, but you could file again, okay? Now, if the name is very different, what does 508B say? Does it say, is it 508? For what, though?
collateral acquired after 4 months?
There we go. So the 4 months shows up again. Okay? All right. And again, here, it's risk shifting. Original collateral covered by the original financing statement, 4-month grace period, then you gotta take some action after the 4 months. So the risk is on the new lender to check for original existing financing statements, but when we're talking about newly acquired collateral that is acquired more than 4 months after the name change, then the risk is back on the original lender. So there's just a risk balancing here that the drafters entered into. They felt okay with the original collateral, they were worried about newly acquired collateral. And then they gave a grace period of 4 months. That's the way I think of it, to keep it straight in my head. All right. Okay, the creditor changes. Does that affect anything?
I have that it's not required to refile,
Why not?
because 9310C.
That is really curious, isn't it?
950.
Does the law require the name of the secured party on the financing statement? It does, yes. What happens when that name becomes seriously misleading? Do you have to refile to fix that? Your answer was?
That it's not required.
Not required. Why not?
Because like the parties already know each other? Well, no, because like he stood out.
So who is going to be confused by this?
Nobody.
Well, the later searcher, right? So a later searcher finds a financing statement for the debtor and they see First National Bank. But now the creditor, the secured party, is Second National Bank. Is First National Bank the same as Second National Bank? No! Doesn't that seem confusing to you?
Yeah, but would you care if they're not looking, you're not trying to figure out their debt, I don't know.
Well, remember, what's the purpose of the financing statement?
To put everyone on notice.
So, and what does it mean to put people on notice?
That there's that debtor.
That debtor has granted a security interest to somebody. So it says what? You have to ask questions. You're the next lender. You do the search. You find your debtor. And then you find this financing statement. And then let's say you call. They won't answer this call, right? They're not going to tell you, yeah, we got a loan with Bob. No, they're not going to tell you that. So you ask Bob, who is maybe your new client, your new customer. And you say, Bob, I found this financing statement. It says First National Bank. What's this? And then Bob tells you, oh, I had a loan with First National Bank, but now it's been bought out by Second National Bank. Here, let me call them, they'll send you the documents. Right? That's a notice system. It doesn't tell you what's real, it tells you what might be real. So do we search by secured party's name in the financing statement system?
No.
Never. We search by debtor's name. It's critical that the debtor's name be right. It is not critical that the secured party's name be right. Because we always have to ask more questions. Bob, I found a secured financing statement. It says you have a security interest that you granted in your equipment to First National Bank. What's that? And you go, Bob will then say, well, I have a loan with First National Bank. We call First National Bank, and they go, well, we don't have that loan anymore. We sold it to Second National Bank. You're going to do follow-up questions. The second lender is not going to lend any money until it knows exactly what's going on. And it's Bob's obligation to tell them, right? It's not the bank's obligation to do the research. It's Bob's obligation to tell them. And if Bob's like, I'm not telling you, are you going to lend to Bob?
No.
Bob's a jerk. Get out of my office, Bob, right? We don't care for the financing statement part of it, what the name of the secured party is. We care only that it's possible that a secured party named First National Bank have a security interest. We still have to investigate. We search under the debtors' names. We don't search under the secured parties' names.
I have a question about how wouldn't there ever be a time that, like, say one company is thinking about buying out another company and they want to know who all they have entered into security agreements with. Is it just, who all have they made loans to, so they, as a creditor,
Okay, so there is a system for finding out who has loans. It's not the financing statement filing system. It's they're called Dun and Bradstreet. And there may be others now. When I was working in this industry, Dun and Bradstreet was the credit agency for businesses.
okay.
So you would pull a credit report from Dun and Bradstreet, and then you would verify against that what was actually outstanding.
Okay.
Yeah. So there is a system, and all these banks report to the credit agency, but it's a commercial credit agency. It's not a consumer one. Like what's the one that we use? There's like 3 or 4 of them now.
Yeah, they're good.
What are they called? The ones that always get hacked.
Yeah, Equifax.
Equifax, right? Yeah. TransUnion. That's another one. Yeah.
Okay,
So this is the same industry,
okay.
just for businesses. Last question. Well, I want to make sure we're okay with the answers to 30. Everybody good?
Is there a
There's
reason?
still one more.
Yeah, this is 31. We got one more.
Is there a reason that they don't make the person just because nobody cares? Or I know you said it already, but
About the name of the secured party?
yes, sir.
Okay, well, I understand, so let's compare this to the mortgage situation. In the mortgage industry, the mortgage document actually is a document of it's an indication of lien, but it's actually a document with legal effect, right? It creates the security interest. So in the mortgage system, you file the document that creates the security interest, called a mortgage. In the Article 9 system, you don't file the security agreement. That's a private document. It does not get filed. So the filing system is only to let people know it might exist. In the mortgage system, we actually care that the right document be on file. So what happens in the mortgage system is that we have these assignment of mortgages that get filed with the mortgage. So we do care, because who can foreclose is dictated by that document.
Okay.
Right? That's evidence of your right to foreclose on the mortgage. So if you go to court as a lender and you don't have the note and you haven't been assigned the mortgage, the court should kick you out of the court and say, no, you can't foreclose. You don't have proof that you own the mortgage. It's not like that in the Article 9 system. Yeah. So what's the issue in problem 31?
There's still one more in 30.
Oh, is there? Did I miss? I'm sorry. And
Sorry.
yeah, no, please, Natalie. I don't want to move ahead when I'm wrong.
I was just wondering about this one, because it says, is Octopus National's interest superior to that of Last National's creditors?
And, sorry, let me just look at my notes here. The S&E ONB here should take the appropriate steps for perfection to perfect itself from LNB's creditors. They would be perfected, so if it's a promissory note, they would take possession. We'll study perfection by possession later. Okay? So that's how they would perfect.
Okay.
Otherwise, they would have to file a financing statement. They just threw that in there just to ask the question, but we will study this later
Okay.
in greater detail. So problem 31, last one. We use that almost all the time. I was hoping to get done earlier, but you asked a lot of good questions, so that's great. Let's go. Problem 31. I should turn the page and actually go to the problem. That would help, right? Robin Oakapple found he could not get a loan unless he had collateral. He got permission from his foster brother, Richard Dauntless, to use Richard's yacht as collateral. Should the lender make both sign the security agreement, only Robert signed the promissory note. Which of these parties is the debtor and which is the obligor? Well, who's the obligor?
Isn't that the person tied to?
Richard, the person who borrowed the money, right? Who's the debtor?
Robert.
Robert. Okay, who signs the security agreement? Well, who has to sign it?
Let's see, Richard would have to sign it?
Yeah, what would
Because it says-
what would Richard sign? Richard's the borrower, right? What does Richard sign?
See, Richard is putting his yacht up as.
All right, sorry, Robert.
For
What is Robert? Who's the borrower?
Robin is the borrower,
Robin. So what does Robin sign?
the promissory.
Promissory note, has to sign it. Does Richard sign the promissory note?
No.
Not if he's not an idiot, right? What's the problem with signing the promissory note?
Promissory note is pretty much be the promise to make the payments.
So if Robin doesn't pay, would Richard be obligated to pay on the loan?
Yes.
Yeah.
Terrible idea.
So who did we say was the obligor and the debtor? 'Cause
Well, who owes the money? Who borrowed the money?
Robin.
Who's the obligor?
Roger.
No.
Wait a minute, the debtor is.
No,
not
who's the obligor? Who owes the money?
Robin.
Robin borrowed the money, Robin is the obligor.
So the person that puts up the collateral is the debtor? That's so weird, okay.
Okay.
Did I not mention this at the end of the class?
did.
We're studying a statute that defines the person as debtor who is not the person who owes the money, but the person who owns the collateral.
But the debtor has to sign the financing agreement, the security.
The security agreement.
And then okay.
So who creates the security interest? The debtor creates the security interest. They grant a security interest to the lender, right? To the secured party. So who has to sign the security agreement?
The Richard, the yacht owner.
Yeah.
The yacht owner.
Like she said.
The yacht owner?
Richard. Does that make sense?
So
Debtor is the person who owns the collateral. You create a security interest in collateral. You do that by a security agreement. So the security agreement has to be signed by
The obligor.
Richard, not the obligor.
Okay.
The person who has.
So
owns
they
the collateral.
can take the boat, and if something happens with the boat, they're gonna come after them? Like it?
Yes. They can foreclose on the boat, but they can't ask Richard to pay the debt.
Payments. Okay.
Natalie, does that make sense?
Yeah, it just sounds like a terrible idea.
He loses his boat, but he doesn't owe the money. So let's give an example. Let's say the loan balance is $100,000, but the boat is worth $70,000.
Makes sense.
Robin still owes 30. The boat's gone, but he doesn't owe the extra 30 because he's not an obligor. He's only a debtor. Yeah.
That's a bad deal by the bank. I would want the collateral to be more,
They make everybody sign everything for this exact reason. They don't want to have to decide. They want to sue everybody, and they want to foreclose on everybody. But the boat is literally only owned by Richard. So only Richard's signature is necessary to create the security interest. Robin's signature is irrelevant. Robin doesn't own the collateral. Robin can't grant the security interest in property he doesn't own. You have to have an interest in the collateral to create the debt, to create the security interest. You have to have an interest in the collateral to create the security interest. Robin's signature on the security agreement, while maybe asked for by the bank, is of no legal significance because he doesn't have an interest in the collateral.
That's like, okay, I get it now.
Right?
Yeah.
Richard has the interest in the collateral. Richard has to sign that document. Richard should never sign that promissory note because the minute he signs the promissory note, he now owes the money too. So when your parents co-sign on the loan for you, if you've ever asked them to do that, the bank can sue your parents for the money you didn't pay. So the smart thing is for them not to sign your loan.
Do people that do this usually have like some kind of other agreement between the two of them? Like, I don't know.
Maybe.
Yeah, pay your bills, I'm gonna kill you.
Yeah, right. Pay your bills or I'm going to kill you. Yeah, exactly. Kill, that's a little strong. I'm going to emotionally damage you. That's what parents do. At least that's what my kids say.
That's okay.
Yes.
So I have a question for the collateral here. In this case, like you said, let's say Robin takes out a loan for $100,000, but the boat that Richard puts up as collateral
Yes.
for $70,000. Do
Yes.
banks or any financer have something where they would want the secured interest to be more than?
Yeah, it's not, I'm not saying that that's a good transaction for the bank, but let's say that you can imagine a situation where the bank is comfortable with Robin, that Robin's gonna pay the money back, but they're a little nervous, so they're like, can you throw something up at least? So Robin asks Richard, hey, can you help me out? And Richard said, sure, I got this boat, it's fine, I don't care, just put it up as collateral, right? That could happen. In most circumstances, if the bank is nervous, they ask for more collateral than the value of the loan. Because here's what they're worried about. They're worried about the unpaid interest in, not only the value of the loan, but the unpaid interest and the cost of collection. So what they collect when they sue is usually more than the balance on the debt. They're hoping to get interest plus expenses. So you want more collateral to make sure you have a cushion should that happen, right?
Do they like have to appraise the boat to make sure
Sure.
it would, okay.
Yeah, just like in a mortgage situation, right?
Yeah.
So when you go buy a house, a traditional mortgage loan is an 80% loan to value loan, right? So they get if your house is worth $100,000 you're gonna buy, the bank will do an appraisal and they say, we'll lend you 80. Because we need a cushion of $20,000 to make sure that we get paid in full, interest plus expenses of the collection. Now, do they always do that? No, sometimes they give 100% loan to value loans. That happens too. Yeah. But if you're a conservative lender, you would take extra collateral. But you don't have to. You're not legally, you could take $5 worth of collateral. It's up to you. Okay? We good about the names and name changes and mergers and stuff like that? The 4 months. I think the hardest part in all this is the 4 months. There's two things that I think is a little confusing. One, you don't have to refile. Oh, that's interesting. But understand it from a systems perspective. The existing lender got a financing statement with a name that they knew, and the system wants to protect them from later name changes that they have nothing to do with, right? It could happen and they could be completely ignorant of. But if they continue to lend and the stuff and they don't make arrangements, they don't want this to go on forever. They don't want new collateral to be added that's forever. They gotta pay attention. The existing stuff they're not worried about, it's the new stuff that's being added. So what they did is they say, name change doesn't affect the existing stuff, and we'll give you a grace period of 4 months. And I think that's where people get confused, is about that grace period, that 4 months. What they're basically saying to the lender is, if you're gonna try and get extra collateral that's newly acquired later, you gotta pay attention. And when you pay attention is after the grace period. After the grace period, you're not protected. Okay? Have a really stupendous, tremendous weekend. Think about this all weekend long. And then come back on Wednesday and get more confused as we start talking about descriptions of collateral.